We're here now with The Legal Answer. It's a segment twice a month here on Studio 10, brought to you by the Sinas Dramis Law Firm and personal injury attorneys, Stephen Sinas and Katie Tucker. And questions are coming from you, the public, and then they'll be able to provide the legal answer. So joining us this week is Katie Tucker. Katie, always nice to see you.
Wonderful to see you again as well. Thanks for having me back.
Of course. And today we're talking about slip and fall cases. So if you viewer was able to ask a question about it. So we're going to start with the basics. When might someone have a slip and fall personal injury case?
Yeah, you might have a viable slip and fall case, or what the law refers to as a premises liability claim, if you were injured because of a slip, trip, fall, or other hazard on someone else's property. Under Michigan law, to successfully pursue and recover damages with a premises liability claim or a slip and fall case, you have to prove four things. First, that the defendant owed you a legal duty. Second, that that duty was breached. Third, that the breach was a proximate cause of your injuries. And fourth, that you suffered damages as a result of that breach. These four elements, duty, breach, causation, and damages, are the very same ones that you really have to establish and prove to successfully pursue any negligence claim under our state tort system.
Oh, okay. And speaking of state, in 2023, so just about a year ago, the slip and fall cases were discussed at the Michigan Supreme Court. So how did that affect them?
Yeah, absolutely. In July of 2023, the Michigan Supreme Court issued a landmark decision that really significantly changed the legal landscape in this area and actually makes it easier for an injured person to pursue a slip and fall case in our state. Prior to this ruling, many defendants were able to rely on what was called the open and obvious doctrine to successfully defeat these types of claims by essentially arguing that a hazard on their property was open and obvious, and therefore that they didn't owe the person who was injured any legal duty. In short, the Michigan Supreme Court's ruling has changed the framework for analyzing these claims, and a finding that a hazard is open and obvious is no longer a complete bar to a plaintiff's recovery. And so this is really great news for Michiganders who have been injured in a slip and fall incident and who seek to recover compensation for those injuries.
Yeah, no, that makes a lot of sense. But do slip and fall cases apply to just businesses, or can we be liable to them at our homes?
Yeah, no, slip and fall cases are not limited to businesses. A premises liability claim can be pursued against both a possessor of commercial and or residential property. In other words, an individual homeowner can be liable for a premises liability claim in the same way that a business owner can be.
Oh, okay, cool. I mean, that makes sense. So where can we find out more information about personal injury law? Because obviously there's so many details, things can change, all of that.
Yeah, so please check out our website, sinusdramis.com or autonofaultlaw.com. There are a lot of resources and pages there. In fact, there's a page dedicated just to slip and fall cases like the ones we talked about today.
Awesome. Well, thank you so much. And remember, of course, you can submit your questions so you can really get the legal answer with the information on your screen. But Katie, thank you so much for breaking it down. It really does help. Going over the basics and going over the changes, really, really easy to follow.
Oh, excellent. Well, I really enjoyed being here, and I look forward to answering more viewer questions.
Awesome. Thank you.
Thank you.